going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you had a great day so far. Happy Tuesday. Happy Tuesday. 2 days down, 3 to go. We're flying through this week. Anyways, you want to watch some court? I want to watch some court. Let's watch some court. What do we got tonight? We have the never-ending eviction case that has been in front of Judge Simpson for I don't even know how long. 4, 5 months now? I don't know. But this is the case made famous by the attorney, Miss Tope. And yeah, no, she's still not here. She still doesn't make an appearance, but they do speak a lot about her. And she was able to mess things up so badly that, yeah, you know what? I'm not going to spoil anything. But it is not looking good for Miss Tope. It's not going forward with her career. I don't know. I don't know. But I'm not going to cast aspersions. We're just going to get into it. That's not the only case we have tonight. I also threw in a clip with I can't remember her name, a blonde judge out of Texas. It'll come to me before the clip starts, but that's a really interesting one with a defendant who just wants to run court his way, and it doesn't work that way. Anyways, before we do get started, got a very generous super chat from Phil. Phil, good to see you this evening. A say late fee. A say late fee. Well, it's not really a late fee when you're early, but I'll take it. I'll take it. It's a great way to start the night, Phil. Thank you so much for the generous super chat. I appreciate it. And welcome to everybody. We're already starting off good. Almost 40 people right off the bat. Let's go. All right. Well, let's just watch the case then. You've already hit that play button. You know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Court does call the case. Fixing Housing 401k plan versus Erica and Aaron Ward. Counsel, state your appearances.
Wayne Valdez on behalf of the plaintiff.
Erica, Aaron Ward, defense.
There might be before too much longer. I don't know, but no bounty yet. I think a bounty it's only technically a bounty if you're on bond, right? I think that's when that's the official bounty is when you're essentially what do they call that? I don't remember the term for it. I want to say court jumping, but that's not what it is. I don't know why that's the term in my head.
All right. I think, counsel, did I not have from you a motion to withdraw?
Your Honor.
Pardon?
Yeah.
Okay. I also have, and I don't know whether or not you were served with them because I'm not clear entirely what Ms. Tope is doing. But did you receive from Ms. Tope a motion to remove and expunge the court's order?
Got an email copy of it that I'm aware of, yes.
Okay, so you...
I don't know the result of it though.
Well,
Thank you, Captain Science. That is what I was looking for. I don't know why I couldn't remember that. Court jumping? What? Was I thinking court jumping when I just said bond? Yeah, that doesn't make sense.
well, first of all, I can tell you part of the result of it is that she marked it an emergency. I did not deem it an emergency. So I set it for hearing today along with the other motions. Okay, that was the resolution. The reason did you folks receive a copy of that?
Not sure what you're referring to. I don't know anything about it.
Donna Tope's motion to remove and expunge the court's order for contempt. Okay.
I don't know. I didn't think I was.
Not received. You got an email copy. All right. So then we received, and I guess I'll deal with that one first, if you don't mind. We received then a communication from Ms. Tope that she was unavailable for her own motion today. So that motion Donna Tope's motion will be adjourned. And I'm not changing anything. The bench warrant is still outstanding. So my next day,
March or April 14th.
14th.
Yeah.
Okay, I'm a little busy that day.
What's going on April 14th?
March 17th.
What's going on the 14th? I want to know. Is that the sentencing for Coach Moore? That's the only time he's been acting like that for the last couple of months. Like I'm going to be busy that day is when there's the Coach Moore hearings.
2026, 9 a.m. So that I'll adjourn the Donna Tope's motions. Council, I'll leave it to you, given your motion to withdraw, as to whether or not you want me to finish ruling on the other motions or hear your motion to withdraw.
What, it's my understanding, the last hearing, you ruled or granted liability or the motion, to start the motion, and we're here today for a hearing on damages, which I suspect we're prepared to move forward with that might result in the conclusion of this matter, which might make my motion withdraw moot to a certain extent, and also make the defendants, we're calling it the second omnibus motion, might make
Pardon?
moot as well.
Oh, yes. All right. Folks, what do you have to say to me on the issue of damages?
So the issue on damages. Okay, so the thing he was referring to as a second omnibus motion. I just was preparing that because I was under the understanding today was the final day. You already ruled on the eviction. You were going to rule on when and the damages. Okay, so since then, there were new things that happened, such as foreclosure being posted.
Oh, she knows. There's no way she doesn't know. The court would have reached out to her. You know, anybody that is her friend probably told her. These two people, you know, I still believe they're still in contact with her. They probably told her. She's just not doing anything about it, which is way worse, especially as an attorney. She would have got a fine probably, but now that she's in bench warrant status for this long, I don't know what the sanction's going to be. But all she's doing is aggravating Judge Simpson.
I've lost a lot of orders and I'm out of business. So starting damages.
You're out of business?
Yes, and I do not have enough orders to pay my lease starting April. Most of the boarders are leaving at the end of March. They saw the posting on the door. Horse owners are like horses. They're flight animals, they're herd animals, and they're all leaving and I'm going out of business. And so I fear, because of the posting is foreclosure on the facility, that he is foreclosing and possibly going into bankruptcy. And so what I'm asking for damages is that it be to come out of the court's account. And that, so that my understanding is damages is up to you. And I have no recourse to get any of my money. I'm out of business. I'm not going to have the money for April's lease because of the eviction.
Let me just stop you there a moment, okay? Because you know about the foreclosure
Yes,
council and it's a bank foreclosure.
it wasn't a bank foreclosure, but it was the lender.
Well, okay, the lender. Have they leaned anything in regard to that?
I'm not aware of a lien. There was a foreclosure sale on the 4th, which the lender purchased the property out of foreclosure. So the redemption period is obviously still ongoing, but
Oh dear. Okay.
Wow. So the lender foreclosed on the property and then bought it back at an auction. That's kind of similar to the video we just saw. Was it 2 weeks ago in that Ohio court with the car, where they had the car repoed and then they bought it back at an auction? Man,
And
yeah, yeah. I mean, they didn't pay. They haven't really paid rent for a long time, right? So they forced a foreclosure essentially. What if they would have bought the property? How sleazy that would have made it even worse. I don't. Can you do that? So many questions.
so when we had received, and I don't know if you were aware of it, counsel, I think it may have come in your, maybe in response to your motion to withdraw communication from your client that it was going into foreclosure. But it actually has gone through that process and then there.
Yeah, and so I just want to make sure that we're clear. So there's the foreclosure sale on the property at issue on the 4th. My client's personal house is also subject to another upcoming foreclosure sale.
That's a different one.
Those are different.
Got it. Okay, and so you have to remind me how long.
Oh, it absolutely is weird when you say it like that, and that's exactly what they did. So they put it up for, an auction to try to get some money back from it, and then they bought it back. So the money that they paid for that property actually goes to on the debt that the landowner who had the original lease. It goes against that, so that comes off. But he still owes them money for it, and now it's free and clear in their name again. So they can do whatever they want with it now.
Was that redemption? That's not a 6-month redemption, is it? Going to be
I believe it's 3, but I
3. Yeah, that's what I was thinking. Go ahead. You were.
I filed this motion so that you would have all the information in front of you so that you could make a final decision on damages. You've already, or whatever it's called. He asked me to be, he evicted me. He asked me to leave. I'm prepared to leave. I've found a place for my horses. Most of my boarders have already given me notice. And because of the foreclosure and the eviction, the fences that have always been falling down are falling down worse. I can't keep the horses safe, but I don't have the wherewithal or the resources to fix them. And I can't go on. And I'm prepared to, if you would be willing to prorate into the court's account 10 days in April, I would be prepared to leave in 30 days from now. And
What did you mean by that prorate into?
Well, so I usually pay at the beginning of the month for the whole month. I won't have the money to do that because majority of
No, the plaintiff in this case lost the property. So he had it on a lease or on a loan from. They said it wasn't a bank. They said it was a lender. So he got a loan to buy the property. They foreclosed on him because he couldn't pay, probably because these two are his tenant. They're not paying him rent. So the lender foreclosed on it. So now the plaintiff's out. He no longer has it. I mean, he still has possession of it now, but there's probably some redemption period that they have to wait through. But the original lender then at the foreclosure sale bought it back. So the original lender got the property back.
Gotcha.
leaving.
I guess. Okay.
Yeah.
That's what you're saying. All right. This is going to be a disaster in the making, I think. When let me do this. While not holding him to it, counsel, is your client seeking to redeem the property or?
I believe in the best case scenario, yes.
Gotcha. You guys are gonna have to, so let's say he doesn't, and then there's a new owner of the premises, you're probably gonna have to leave in any event. So when can you,
That is just my assumption. I don't know if it's, you know, a huge plot of land and they only had a portion of it, or if they were renting the whole portion. That's just my assumption. I don't know why the foreclosure happened. But that would just, I feel like that's an easily made assumption. I don't know if it's 100% true, but I don't know. It kind of makes sense.
you guys leave the property?
I would love to leave April 10th, but I can leave at the end of March. At the end of March, if you're not able to give me a prorated lease payment for the 10 days of April.
What do you have? A total in escrow?
20,620.
Say again.
20,625.
I'm sorry, Your Honor, you said that's what's in the court's escrow?
Yeah, I was asking. It was 2625.
20,625.
And you folks have already paid the March payment. Right.
Quick question, the March payment, are we saying that was paid into the court's escrow?
Yes, they said they paid that.
Last one being February 5th.
So you don't have a March.
One dated March.
I didn't bring the receipt with me, but I did pay it March. I paid it. Did I pay it at the end of February because it was before we left on vacation? I think I paid it the last Friday of March because we left on vacation Sunday, so I want to make sure it was in before we left.
Did you pay?
I'm sorry, the last Friday of February. We paid it cash the last Friday of February.
Did you pay it here?
Or in Tulane.
Well,
It really wouldn't matter. Do you know what court you went to pay it?
no,
I do see it because you paid it here. It's not on the ROA. So
And then it's got to be transferred over. So 5,500 additional.
so $26,125.
Yeah, she was held in contempt. She was forced, or Judge Simpson. Okay, Judge Simpson held her in contempt, and scheduled a show cause hearing. She didn't show up for the show cause hearing, so he issued a bench warrant, and she's still in the wind. So I think some people have said that she's supposed to be in front of him next week. I feel like a couple people in the chat said that, but she's still pulling strings in the behind the scenes. At least we assume that's what's happening. But yeah, she still is not showing up.
How long was your lease?
it was supposed to be 7 years.
You have how many horses are you moving?
I'm sorry, how many am I moving?
How many? Yeah.
Just my personal horses. Everybody else,
Okay, that doesn't answer my question. You're getting like that other guy.
I own.
3. So come the 10th, as you're anticipating, you're moving 3 horses. Or are you moving 3 horses and then some others that you're in care of? I guess I'm trying to.
There's 3 other horses that are absentee owners, and I haven't reached out to them yet because I was waiting to see when my leave date was. I'm gonna reach out to them and see if they want me to take them, because I'm just going to a friend of the family's and they're just pasture horses. But no, I'm not continuing this business. Does that make sense?
No, well, yeah, there's a lot more information I needed, but I'm just trying to figure out if I were to give you till the 10th, you're moving at least 3 horses, but up to 6
Yes.
total horses.
Me personally, yes.
Right. Okay.
They haven't covered that motion yet. Judge Simpson asked them if he wanted to address it at the beginning, and they didn't address it. My guess would be, I mean, if the guy just lost his property and he's about to file for bankruptcy, he can't afford his attorney. That would be my logical guess. I don't know if it's right, but that's my guess.
And as you're moving them, I know approximately what it's going to cost to move horses, but I don't know how far you're going. What's your cost in moving those horses? Just give me your 3.
$100. I mean, if that. It's my trailer, my truck,
Okay.
my gas.
So you don't gotcha.
Correct.
All right. Okay, before I make a final determination of the damages on this, any other additional argument you want to make regarding the?
Yeah, a couple points,
Yes, sir.
just so that when I'm on the same page and we're all on the same page. So I have back in June of 2025 was the last rent payment. And it was a partial payment that was the water heater. Subsequent to that, until this court directed Ms. Tope and defendants to submit money to the court's escrow, I believe there was the subject of a number of hearings prior to this that Ms. Tope had an escrow account personally where she was maintaining monies of some sort for June until, because I have, for example, as of March, a total outstanding rent due of $48,691.04. $26,125 of that is accounted for in the court's escrow account. The other $22,000 and some change might be in Ms. Tope's escrow account, which started this whole issue. And so
can I just stop you there? That you understand what counsel's indicating about the difference in the money?
One correction, I did pay Fixing Houses LLC directly in July. I paid them the full amount in July.
Okay, but we still have a discrepancy amount. So I'm going to ask you folks a question, okay? Did you give that money of these missing, I'll call them missing, but the payments that did not get to the plaintiff, did you give those monies to Ms. Tope?
They were dispersed. That's the money that was dispersed for repairs.
Okay, but what I said, yeah, okay.
Yes.
Hold it. You did not, okay, listen closely to my question because it's really important. You did not disperse those funds for repairs, right? You gave that money to Ms. Tope, who was holding it in whatever to then disperse for repairs. or pay for it?
Yes,
Okay, because hold on, understand, there's a reason why I'm asking this, and there's a big difference. Okay, because what council's indicating, I believe is correct, but I just want to make sure on the record that we have it. The 5,500 that you would pay each month that you would have normally paid to the landlord in this case. There were some months you paid those funds to Miss Tope to hold and or to use for repairs and other things.
Oh no, they were legit repairs. They were, $10,000 for 6 light bulbs. I mean, that's legit, right? I don't remember what the repairs they were talking about, because that they had that hearing a couple months ago, and all I remember, it was something about lights was one of the arguments. I don't know what the repairs were. They're, I don't know. They kept saying safety hazard. I remember the safety hazard and lights is all I remember from that hearing.
I believe that was August, September, October. July, I paid.
Hang on a second. Hang on. Just slow down. I didn't ask what months. I want to make sure that factually because Ms. Tope's not here, factually that's correct. Because that's what I understand also, but I don't know that you've ever been asked that directly.
Yes.
Okay.
Oh my gosh, Mortimer Duke. I just missed you just put this in my head. That's probably where your comment came from, but I missed a golden opportunity for a great title to this whole saga. Only Fools and Horses. Man, golden opportunity missed.
So there's then this escrow, and you're saying that was 3 months, if I'm hearing you correctly, that you would have given the monies to Miss Tope.
I would have to look at the accounting records, but I believe it was August, September, October. I believe it was
Yes.
August, September.
November, it paid to court, right?
Our first payment was, I think that's right.
And just so that we're on the same page, I believe the November payment was paid to my client and it was a partial
It
payment.
was a partial payment in November. Right. So,
But I also paid
but you paid the difference of the 55 to the court. No, you paid the 55, but part of it was the check he received.
It was a double payment that month because of an error by Ms. Tope. So he received the check from Ms. Tope. He also made the payment. So that month had extra.
I believe in November, we paid the full 5,500 to the court. Is that correct? Or was it 41?
You pull me
25 is what we.
He received it
41.25.
Yes.
He got 3,600.
on top of that.
So it was more than the 5,500.
It was $3,508.96.
I remember that being paid. Because that was a check Ms. Tope sent to him, right?
I don't know how we got it, but my records show that we got it.
Right, that you got it. And the question was whether or not you could pay or whether or not you could use it. And because there was then the full amount, I said, you guys keep that money. The difference,
How did I defame Mr. Ed? I don't want to. Was it the Only Fools and Horses? That's a title of a TV show. I don't know. Sorry, Mr. Ed. I apologize.
thought was being paid into the court.
And so I accounted for that in my previously stated number. So I'm just trying to bridge the gap between what the court has and what hopefully should be in Ms. Tope's escrow, personal escrow. No.
Okay. And that number you gave me was 48,691.40.
Not 44, so 4 cents.
4 cents.
4 cents.
In November, though, it was overpayment. Because we paid
Well-
25 and 3,500.
Well, I don't know if we can really look at it as an,
Okay,
I mean, because ultimately there's going to be a certain amount that should have been paid. The real question is where it went. I guess is that.
I think that's what you were gonna ask for.
Yeah, that's what I'm. Okay, and I know why that happened. What I did is I think I prorated. So I allowed him to keep the check. It really wasn't a double payment. So here's what I recall doing is the money that was sent to the plaintiff, I allowed him to keep that upon the court's original. And then when ordering escrow, I ordered it pursuant to the court rules so that it was ordered prorated for the period in time. And I went back, although you paid it on the 18th, it was back around the beginning. When was our first? You didn't run the whole thing, but whatever our first date in November was, I prorated it from a date in November, which is how we came up with that number. So there wasn't a full amount that was going to need to be paid in November. All right. You complied with the escrow order. If you didn't understand all that technicality and what I just said, but I understand why that number is different. And I didn't order the whole 55 for November. All right. But in terms, okay, so here's going to be the problem. And I don't know whose problem it's going to be. And this is going to, I don't think that the monies you paid were properly put into a trust account with Ms. Tope. That causes huge problems, which I don't know what I'm going to do with it there. Because and I'm not sure of the procedure, but typically, and I know it's changed certainly since I've had to do it, where an escrow account or an IOLTA account is mismanaged, there are ways to the state bar of making the person whole. Now, having said that, and that's there used to be, well, I'm sure there's got to be a way of doing that, but I just don't know how that is. Because you guys are never going to see, well, let's put it this way. You guys are never going to see that nice term. Have you asked her for the money back?
No, they're not.
I don't think that money's there. I think that that's the money that was used for replacing the sheds and all of that. So,
That's not as-
okay, no, I'm never gonna get
But-
my money back.
Here's the problem, okay? And just follow this here. Okay, and I think, guys, he's got an Alabama shirt on. Tackle him. No, I'm kidding. Okay. Under the terms of the lease, which is the basis upon which I indicated the monies, you have to pay them, right? That money should have been paid over the plaintiff. Okay?
Money should have been paid every month.
Been paid over to the plaintiff.
Should have been paid
Yes.
over to the plaintiff. Okay? I ruled that.
Yes.
Okay? The problem is that it's hard. So I can't really necessarily give an offset. What really should happen in this case, right? Everything being equal and everything being what it is, and if Miss Tope were participating as one would think a member of the bar should, what should happen is the moment that I ruled that that money should have gone to plaintiff, regardless of whether she spent it on it, if she did that improperly out of an IOTA account, she should then pay that money to plaintiff. Right? You guys wouldn't have to pay more. Okay. That's not gonna happen. I don't think. So while let me put it this way. She may have told you those were legitimate expenses. They weren't legitimate expenses.
I hear you.
And so what I'm toiling with, just to be honest with you, is in looking at these numbers, do I hold you accountable for that? Or what do I do with it? Now, I'm toiling with that because also, which is also part of the hearing that I adjourned to the 17th, and why I would be reluctant to let counsel out right at this moment in any event, although it may be moot, is because the bond that I set on the contempt, that would be money that Miss Tope may pay in, was specifically going to be directed toward attorney fees that were being exponentially imploded because of Miss Tope's actions. So I'm going to ask you guys to just give me a few minutes. I'm going to step off because my problem is everybody in this courtroom has been hurt by this person. And I'm trying to find an equitable way to deal with that. Counselor.
I have one suggestion.
Yeah, sure.
And theoretically, how it should work is if the defendants have paid money to their attorneys in IOTA account, equitably, that's still their money, which as you alluded to, would mean that that money is no longer there. They would have a claim against Ms. Tope, most likely through the bar agreements or whatever form they choose. My client does not have that remedy. And so, because we don't have a relationship with Ms. Tope. She's not my client's counsel. She didn't hold, I don't have an IOTA account with her, or neither does my client, for example. So in this scenario, the money that was in there, the defendants, I mean, their contractual obligation is still on them. So if they pay, then their remedy would be, they would actually have a remedy to get it from Ms. Tope, where my client really theoretically would not. I mean, there might be a creative way to do that, but I'm not aware of this. I've never had a situation like this before, but
you wouldn't me either. But no, I hear you. And that really had gone through my mind. But and that may be where I land in the next 15 minutes, right? But This is the second case in which Ms. Tope has been involved where people have been damaged. This is really the only one, however, that has damaged both sides, and then to a certain extent, the attorney on the other side, because your fees haven't been paid. And I want to just take a moment to think all that through. If I come up with something creative, I may come up with something creative, or I may not. I mean, I may indeed, and I appreciate what you're saying, Council. That's where I may land. But I want to just think about that for a moment, because I, quite frankly, have never been through anything like this before either. And, you know, your client's out, your fees, plus he hasn't gotten the rental income. These folks have paid they're out at least what that difference is because they paid it over. So, and now, because of all of that, and I'm not saying it's the entire cause, but because of all of that, he's in foreclosure. You're not in business. It's a beautiful scenario. And it shouldn't be how things should work. And over my 26 years, I'm not sure I've seen one person cause this much damage. Court's going to stand in brief recess.
All rise.
All right. All right. Did you like that? Did you like those editing skills there, Bill? I'm not going to say anything else about that. So I've never seen so much damage caused by one person, and he's also a criminal judge. Man, real quick, Phil, thank you so much for the 5 gifted memberships. Welcome to the 5 new members. I appreciate it, Phil. Sorry, I waited a little bit to thank you for that. I thought that break was coming a lot sooner than it was. I had a bad judgment at times, so I do apologize, but I do appreciate you, Phil. Thank you. All right. Yeah, I don't really have anything else to say. That he took, I mean, a 15-minute break for Judge Simpson was about 30 minutes. So that's what I just cut out. Let's go.
We are back on the record in the case of fixing housing 401k plan versus the wards. Council is present and the wards are present. Folks, here's what I'm going to do, and let me just explain the beginning of one of the things I wanted to check on.
Yeah, and I've been wanting to pause and make that exact same comment, but I didn't know how to word it without making it sound like I was blaming the plaintiff or the landlord. I just wanted to, kind of make a general business comment, but it's like, yeah, I'm just not going to. So my head was there, so I do appreciate you saying it, so I didn't have to. So thank you.
During my break, there may not be a remedy through the bar. The only reason I say that is because at a previous hearing, Ms. Tope had indicated she was not acting as an attorney, and therefore there was no need to put it into an IOTA. True or not, I'm just saying what was said. Taking that into account, I'm going to do it this way. I am going to award judgment to the plaintiff, the monetary part in the amount of $48,691.40. I am going to order that the $26,125 is to be paid to the plaintiff. The resulting balance, I'm going to indicate, cannot be that no collection proceedings regarding that amount can begin against the wards until May 31st. I'm picking that date to give them time to figure out if they have other remedies regarding that balance and give them time to sort that out. Should they seek to get counsel? Should they seek to go to the bar? Whatever they may wish to do. So I'm giving that time frame. I am going to order that an order of eviction will not issue, can issue April 30th. I'm going to give additional time for to vacate the premises. You can have until, I mean, if you get out the 10th, that's fine, but they can't do anything until the 30th. I'm going to give you the month of April to get out.
Okay,
Yes.
it is what it is, but I don't know that I'll have the money to pay the lease at the beginning of April.
No, I am not going to order that the $5,500 for April be paid.
Okay, so no payments,
No payments for April. March is already in, right?
So no additional payments at the conclusion of this hearing, period.
Provided you vacate the premises by April 30th. If you,
No.
if you're out of the premises May 1, you owe April.
Okay, so no additional lease payments, period. Unless I don't leave.
Right. If you're not out in April, then you need to pay the monthly. You have to pay April and then the subsequent May month.
Okay.
So you'll have to pay 11,000.
Okay. And the 26,125 is the number that you came up with that I paid into the court's escrow.
That is the amount we have in escrow.
Okay. And
That's
so the
paid over to the plaintiff.
what we're still trying to figure out now, will my $7,500?
Yeah, that's fair. That's a fair comment, Matt. Yeah, it's one of the reasons I was debating even making that comment. It was just in my head, and I have a problem when something's in my head, I say it out loud. Doesn't mean I'm right, but I do agree with you.
Security deposit come out of that balance? So would I pay it?
I typically do not deal in a landlord tenant proceeding because there's a whole nother section of statutes that apply to security deposits. I don't deal with nor take into account that. Since I will say this amount, since the amount of these amounts are rent under the Security Deposit Act, he can take that 7,500 and apply it to whatever rents due. So theoretically, it would go against us in any event.
It should go against then.
Well,
money.
ma'am, what did I just say? I said basically the framework of the Security Deposit Act is that I am not ruling that.
Okay.
Because I don't deal with the security deposit because you have not vacated the premises. All right. The other thing, one last thing is that the hearing, Ms. Tope's hearing, I'm going to move that from the 17th to the 18th at 9 a.m. at a special time. I do not need the parties here currently present because I don't know that you have an interest in it. I will indicate to counsel, as I had said at the last proceeding, the amount that I had set on bond on that was to cover attorney fees that were related to the delays on that. If you would, so that you do not have to appear at that hearing, if you can submit a billing to my office that we can just hold so that I at least have that figure in mind.
If I have an affidavit right here,
Fantastic.
it's current as of today, so if we don't have to show up in the next one, this should be sufficient.
All right, fantastic.
And I'll just let the, we have redacted invoices, both like seeing unredacted invoices. I highlighted the days. You'll see.
Got it.
But if you want to see the unredacted ones, have to provide that for an in-camera.
All right. And I don't know that I'm going to need that because counsel, I think I trust you, and certainly I don't think your firm would allow you to give me something that wasn't right. So, all right. All right. Okay. Anything else?
What do I do next to, like, is this done? Do I have to,
This case is done. I've issued, it's done because I've issued the date that you can stay in the premises.
Okay.
I've also now ruled on the issue of liability with the monetary amounts that I've indicated.
Right, but I'll hear from them about that at some point.
I would imagine you,
Okay, so I don't need to
Okay.
do anything, okay?
you don't need to do anything Ms. Ward, so that you understand what I'm doing. I'm not allowing them to take collection efforts as to that difference till May 30th, 31st, the end of May. The reason I'm doing that is because, as I think I had indicated from the very beginning of this case, you may have claims as against Miss Tope.
Okay.
That can come in various forms. Okay. And so I'm not suggesting one or the other. I'm just giving you an opportunity to explore your options as to how.
Yeah, I'm not telling you what to do, but I'm telling you have options. You might want to look into him. He is coming so close to giving legal advice right now. And I think he's right. He should be pointing them in this direction. So I'm not mad at him for it, but he's trying to choose his words really carefully here. You know, you have actions. You can do some things.
You remedy this, because here's the cold hard reality. You're going to be out an additional whatever amount unless somebody makes that up. But counsel's right. It's not the plaintiff's obligation to do that. It's going to be whatever you decide to explore that.
Okay,
Okay?
so is there gonna be something signed and sent to me, or
Counsel will prepare an order. Counsel for the plaintiff will prepare an order for the courts.
I'll get a copy, and so I'll know that it's done, and I never have to see you again.
Well, thanks for saying it there. But I appreciate it. Yeah.
Oh, yeah, I cut it off right there. There was like another minute or two of that case, but they were just kind of small talking a little bit. But I did forget I cut it off there. So, but there we go. There we go. Yep, never gonna see Judge Simpson again. Unless they, decide to file a lawsuit against Miss Tope, and he just happens to be that. No, he wouldn't do that. He doesn't do civil cases. Well, he does landlord tenant, but he doesn't hear small claims or those kind of cases. So I wonder what attorney or what judge that would go to. That'd be interesting. Anyways, yeah, landlord kind of got screwed there. It was, and I don't really like that Judge Simpson gave them until the end of April. And but I said this the last time that when they're dealing with horses, he wants to make sure they get all the horses off the property. It's just, I think they said they only have 3 horses left though, and they already have a plan for that this weekend. Why do they need that much time? I don't know. Maybe I missed something in the explanation there. I don't know, but they only asked till like April 10th. They asked for 1 month from today, and he gave them essentially a month and a half. Um. Anyways, it's over. It's over. Hopefully, the landlord can recover something from this. Hopefully, the escrow money that he should be entitled to won't get. I mean, that might stop him from going into bankruptcy. Hopefully. All right. Anyways, I got one more case. Ah, man, I told you I'd look. Oh, Judge West. I knew it. I was like, I know I'm going to remember her name before the clip starts. We're going to Judge West Court. We're in Texas, and we have a guy now. A little minor trigger warning. What he's in jail for right now is pretty serious. You know what? You'll hear it, but they don't go into the details of that because it doesn't really matter for this case. Well, it kind of does, but not really. They don't go into details about it. Just I'm just giving you guys a heads up. Phil, thank you so much. Thank you so much for the super chat. Has anyone spotted the dinosaur on Judge Simpson's desk? Yeah, he plays with it every once in a while. It's like a little rubber thing. Like he'll play with it. But yeah, no, it's cool. But Phil, thank you so much for the super chat. I do appreciate it. All right, let's go, Judge West.
Okay.
He knows a lot better than me. He's already in prison for murder. Out of another county.
But he signed it, but he.
Yes, I'm just saying.
Okay.
How
It could be
he wanted to say no contest. He wanted to different things the law was to you. Oh, yeah. Did Philip sign them?
Mm-mm.
I'm sorry, Judge.
All right, so that was this guy's defense attorney talking. He's like, oh, he wants to plead no contest. He knows the law better than me. All that little side chat right there, that was the defense attorney just giving the judge a heads up of what's about to come. So yeah, that's not a good sign.
I'm taking police laws.
Good morning. Are you Victor Charles Campbell Jr.?
Yeah.
And Mr. Parker, will your client waive the formal reading of the indictment in each case?
Here we are.
And it looks like we are going in 21-36426 and 22-39050, correct?
There's also a dismissal in 3059.
And are we going on all of the counts or?
No, not on. We need to go on, well, in 36426, he will need to be true to the one enhancement paragraph in the indictment
Okay,
and, count one only in the other. Right.
all right, Mr. Campbell. In cause number 21-36426, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle, and that's from November 28th of 2020. The indictment further alleges that you were previously convicted of assault family violence, a third-degree felony, December 5th of 2014. And how do you plead to that charge?
Okay.
So to the charge, let's start with just evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge? Guilty or not guilty? There, it's guilty or not guilty. Either you did it or you didn't do it.
I thought that's what the plea was.
There's a plea agreement means in my court, you either enter a plea of guilty or not guilty.
Guilty. Okay.
Mr. Campbell, I understand that you're already doing time for a murder and that you don't really care about what's going on today.
I'm saying I plead no content because he never even went over the indictment with me.
Yeah.
I find that hard to believe. So here's the
To
thing.
actually be honest, I just only been here for like about 30 days. So I got like 3 weeks or 30 days and about 2 weeks of being here.
Here's a picture
in both
one here.
Yeah.
So, the nature of the crime, no cause number, and the magistrate, as far as the indictment, I never received one. And due to the fact of the nature of the charge of being from 2018, you have 5 years or 4 years to indict me to actually send that indictment. After
Sir, the
that's
allegation,
why I'm pleading no contest.
I'm not going to
I
allow.
find guilty. It's fine.
Here's the thing, I don't have to accept any plea agreement.
Yes, ma'am.
Okay, so you can, in that evading arrest or detention case, if you go to trial and you're found guilty, it's habitual. You're looking at 25 to life. We can set it for trial. I'm not playing games and I'm not going to accept the disrespect. If you want me to follow this agreement and go along with the plea agreement and you can go on, do your time and be done with it, then we can get that done. But you're not going to show disrespect while we're doing it to me. Do you understand?
Yes.
So if you want to go forward, we'll go forward. If not, we'll set it for trial. Mr. Smith will get ready very quickly and we'll get your case tried within a month. And it'll be habitual 25 to life. What do you want to do?
It's 18 years.
No, the plea agreement.
If you go to trial, listen to me. If
Yeah,
you go to
fine.
trial and you're found guilty and your prior convictions, stop talking over me. If you go to trial and you're found guilty and those prior felony convictions are true, then you're looking at habitual 25 to life. Today, there's an agreement for something different. I'm glad to accept that if that's what you want to do, but you're going to either accept responsibility and plead guilty or plead not guilty.
Yeah.
That's your choices. So let's go back then and cause number 21-36426. You're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge? Guilty or not guilty?
That's what I'm saying. You saying assault family violence. The invading arrest is I
Listen.
plead guilty.
It's evading arrest or detention
But
with
what
the
are you
use.
looking at? I'm saying,
I'm
Look,
looking at your indictment.
He's saying you got indicted for
I got that.
evading. In 2014,
Right.
you were
Hold on,
convicted of
this,
something
Mr.
else. Okay.
You've probably already tried. Let me take care of it this way. Give me just a second. Which one is being dismissed? 5-1 or
39051.
Okay. Make sure you don't get my information mixed up with him.
Who's?
Or whoever that information is, I ain't gonna say his name on the record.
That's not me.
Just a second. Well, it's taken care of. I should have 2 indictments. So just release.
Oh no, the dead air. Sorry, guys.
All right. Place that in front of your client, please. Now, that is cause number 21-36426. That indictment alleges in paragraph 1 that you committed the 3rd-degree felony offense of evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge?
I just pleaded no contest. She didn't want to accept no contest.
How do you plead to that charge? Guilty or not guilty? We're not going backwards, okay? I already told you you're not going to plead no contest.
Guilty or not? You plead guilty or not guilty?
So if I'm telling you no contest, what is that?
It's nothing and it's nothing. You're not allowed. I can take a plea of no contest or I cannot take a plea of no contest. That is up to the court. You're not legally entitled to plead no contest if there's a plea bargain. I'm telling you, if you want me to accept the plea agreement, you're going to plead guilty or not guilty. I've already told you that. I'm not going to tell you again. If I have to tell you again, guilty or not guilty,
I'm saying.
period. That's your, I'm
That's
about
saying
to
that
set
I'm
your
not-
case for
that's
trial.
saying that I'm not. That's basically saying that I'm.
We're not going to
guilty
argue the
or
law.
I'm not, or I'm guilty.
We're not arguing
That's
the law.
basically just saying that I
Doesn't-
state that.
I'm not going to
Go
argue
ahead.
the law
Fine,
with
no
you.
guilty. Just sign. Go ahead.
I
Put it
don't-
as guilty. Go ahead. That's what y'all want anyway. That's
Listen.
fine. I'm cool, man. Just go ahead. and
Well,
get
you're
the
not.
guilty.
You're really not being cool, and you're making me very frustrated.
Ma'am, I respect your call. Just go ahead and give me the
It
guilty.
nothing here.
Plead guilty. There
Okay.
you go.
So you plead guilty to evading arrest or detention
Yes,
with the
ma'am.
use of a vehicle. Okay. The next count, the next paragraph that you're looking at says that you were previously convicted of assault family violence December 5th of 2014. Is that true or not true that you have that conviction
That's
on your
true.
record? Okay.
And that's not the same
That's
case
okay.
as far as
Look-
evading arrest, ma'am. That's 2 different charges. So if you really want to be technical as far as being a habitual, that's called a repeated offender. But
Exactly. And that's,
that.
listen, so Mr.
That's
Campbell,
15.
wow.
I think.
Do you want to come sit up here and be the judge? You're so smart.
I don't know. If you needed some help, ma'am, I wouldn't mind.
I feel like I might because I'm not understanding.
Yeah, that's called sarcasm. Yeah, yeah. Stop talking. Go, Judge West.
Mr. Campbell, you're getting a deal to go on count 1 only, which makes you a repeat. I get that you've been through this before and you understand what's going on, but you're making this more difficult. If you go to trial, you could be habitual. Today, if we take this great plea agreement, it's repeat. I understand that. I've been doing this for 30 years. Okay? So, did you enter your plea of guilty freely and voluntarily?
Guilty.
Did anybody force you to plead guilty today?
No.
Okay, so I have well, let's go to the next case then. In cause number, and here's that indictment. In cause number 22-39050, you're charged with and in this case, we're just going on count 1.
Count 1 only.
So in this case, we're going on count 1 only. So it's just the offense of tampering with physical evidence, a 2nd-degree felony from November 28th of 2020. And how do you plead to that charge? Guilty or not guilty?
Pleading no contest, but guilty now.
So are you pleading guilty to this charge?
Yeah. that's
Okay.
actually-
And did anybody force you to plead guilty in cause number 22-39050?
We just answered it.
I know I have to ask you in each case. It's required by law. It's required by law that I ask you that in every case.
Just pleaded guilty.
Okay. And nobody forced you to do that, right? Speak up so the record can take it
No,
down.
I think you did. You did, but let's
I mean, he's not wrong. So, yeah, Judge, you actually did force me to plead guilty. But yeah, no. That's such a weird question in that situation, though.
so no.
Okay. So I have in both of those cases here on the tablet, some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed those, did you go over them with Mr. Parker? The documents on the tablet, y'all have that? And do you understand if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving any right to appeal? Yes or no, please? Do you understand that?
Understand what we signed, the document.
Okay, you have to answer out loud, yes or no, so that the record's clear that you understand, that I know you understand what you signed, okay? I'm not trying to, doesn't have to be that difficult. Just get in, get your deal and get out. You're making this way more difficult than it has to be. Do you also understand, if you're not a US citizen, that a plea of guilty or no contest could result in your deportation? If you're not a US citizen, could result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law.
So what this is, I don't.
I'm required to ask everyone that. Are you a US citizen?
Yeah.
Okay. State tenders number 1 in each case.
Objection.
It's admitted in each case. Is there any evidence that Mr. Campbell is not competent?
No, you're gonna.
You said
I just printed the wrong thing.
She asked me if I thought that there's evidence you weren't. I said, no, there's not. He's confident.
I just printed the wrong stuff. Did I print both of the
You can be.
certifications?
Thing on that, sure. Instead of
Blank.
please.
Okay. All right, Mr. Campbell, I'm going to find in each of your cases that you, Mr. Campbell, pay attention to me for a second, please.
Oh, fell, please. I ain't drinking,
Mr. Campbell, you ready?
Yeah.
In cause number 21-36426, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with the use of a vehicle. Find that prior conviction true. Sentence you in accordance with your agreement to a term of 18 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
So can you say that on record?
I'm on the
Yes.
record.
No, I'm saying say that how long I've been in custody.
I don't know.
I've been
I don't
in
have that
custody going on
information.
5 years.
Okay, you'll get all the credit that you are entitled to get by law. And cause number 22-39050, also find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of tampering with physical evidence. Sentence you in accordance with your agreement to a term of 18 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These two cases will run concurrently, which means together at the same time and concurrently with any other sentence that you're currently serving. I have signed a dismissal as part of this agreement in cause number 22-39051. I'm handing you in both of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk with your attorney. You can go back with the bailiff.
So do I get my papers for my time served?
Go back with the bailiff.
Is you gonna bring me my papers for my time
They
served?
have it at the jail.
Excuse me?
No, they have it at the jail. No. I told you.
You didn't tell me.
So he wasn't that bad.
I mean, this one might be difficult, and Judge, this one's really gonna
He-
push you over the edge difficult.
All right. All right. That one was kind of fun, right? Yeah, you know, when you're when you're trying to take a plea or the guy's in jail for life for murder, right? Like, there's really nothing you can do as a judge to I don't know. It just that's a difficult position to be on. That guy, it doesn't matter if she holds him in contempt. He's not going anywhere anyways. Difficult position to be in. Anyways, I think she handled it well. That guy's special. We'll leave it at that. Anyways, that's it. That's all I got for tonight, guys. Thank you so much for hanging out with me. I do appreciate it. It was a great show tonight. Thank you, Phil, for the super chats and the gifted memberships. I appreciate it. I think that was it. Phil, yeah, just Phil tonight. Thank you, buddy. Yeah, I've got it set up to rate Katie Zed. Since I'm getting off a little early, she's the only one on. So we're gonna go head over to Katie Zed and tell her I said hello. Thank you guys so much for hanging out with me. Mods, as always, thank you so much for your hard work. I'll see you guys tomorrow night at the normal time at 8 o'clock. And then Thursday back to 7. Anyways, you guys are awesome. Have a great rest of your evening. Till next time. Bye.